Hello friends, thanks for tuning in. I welcome all of you to my YouTube channel Legally Determined. This is Sanjay Arora. By profession, I am an advocate in Delhi. The Union Law Ministry, headed by the Honorable Law Minister Mr. Arjun Ram Meghwal, to amend Advocates Act 1961 with the new draft bill 2025 made public on February 13, 2025 on the website of the Department of Legal Affairs for inviting comments, takes hold fast after encountering stiff resistance from the legal fraternity and withdraws the draft bill amid backlash from the stakeholders, because the draft bill is against the autonomy and integrity of the legal profession. First, the insertion of Section 4, Clause 1, Subclause D of the Advocate Amendment Bill 2025 provides for the central government to nominate up to 3 members to the BCI. This provision is fundamentally opposed to the structure and independence of the Bar Council, which has always been a democratically elected body representing the 27 lakh advocates of the country. The proposed draft bill allows for the excessive government interference into the composition of the Bar Council of India, thereby deviating from the principle of self-autonomy and self-independence. This draconian provision turns the Bar Council of India into a government-regulated body rather than a self-regulating professional body. Suggestion: instead of direct government nomination, an independent panel of retired Supreme Court judges and senior lawyers should nominate these members. Second, Section 35A of the draft bill calls for the blanket prohibition on the boycotts or abstinence from court's work. Instead of creating a proper forum to allow lawyers to raise their grievances and issues, the proposed draft bill takes away lawyers' rights to raise legitimate demands by way of a boycott or abstinence from work, with the imposition of penal consequences if obstruction in any form in court's functioning or in court premises is caused. The violation shall be treated as misconduct and the advocate shall be liable for disciplinary action as contemplated under the Act and regulations, provided that advocates may participate in a strike only when it does not impede the administration of justice, such as strikes intended to bring attention to legitimate concerns about professional conduct, working conditions, or administrative matters, and may include symbolic or one-day token strikes as long as they are conducted in a way that does not disrupt court proceedings or violate clients' rights. Article 19, Clause 1, Subclause A of the Indian Constitution provides for the freedom of speech and expression, and Article 19, Clause 1, Subclause B of the Indian Constitution provides for the peaceful assembly and without arms. Suggestion: strikes should require prior notice to the Bar Council of India and courts. Third, the Union Ministry of Law and Justice has empowered the government through Section 49, Clause A of the draft bill for the regulation of foreign law firms and cross-border practice into India. In Bar Council of India versus A.K. Balaji 2018 5 Supreme Court 379, Supreme Court held that foreign law firms or foreign lawyers could not practice the profession of law either on the litigation or on the non-litigious side unless they complied with the provisions of the Advocates Act 1961 or the Bar Council of India rules. Suggestion: reciprocity principle. Allow foreign law firms only if Indian lawyers are allowed to practice in their home country. Fourth, the insertion of Section 49B in the draft bill that provides for the power of the central government to issue binding directions to the BCI, that is again ultra vires the Constitution and the Advocates Act 1961. Fifth, the fixed enrollment fee of 18,000 rupees to the State Bar Council and 3,000 rupees to the Bar Council of India had been fixed. The Ministry's draft bill leaves the determination of the enrollment fee entirely to the central government to be notified from time to time. The Bar Council of India deprecates its sixth addition of a new Section 24B, removal of the name from state roll. The name of the advocate shall be removed from the state roll if he is convicted of an offence and sentenced for a period of 3 years or above, with or without fine, and the conviction has been confirmed by the High Court or the Supreme Court, provided that in case period of sentence is less than 5 years, the advocate may, after 2 years have elapsed since his release, make an application to the State Bar Council for re-enrollment, and the State Bar Council shall consider such application in consultation with the Bar Council of India in accordance with Section 26 and the regulation made in this regard. 7th, 36B3 of it is evident from the record that the State Bar Council or its disciplinary committee has failed to conduct effective hearings, exhibited negligence, or shown lack of diligence in hearing and disposing of complaints within the stipulated period of 2 years as prescribed under subsection 1. Such failure may be treated as misconduct on the part of the General Counsel of the State Bar Council or its disciplinary committee, as the case may be. 8th, Section 45B, liability for misconduct in certain cases. If any person suffers loss either caused deliberately or by misconduct of the advocate, then such person may make a complaint of misconduct against the advocate under appropriate regulations as may be prescribed by the Bar Council of India. For deciding the liability of the advocate, an important question on whether advocates are liable for alleged deficiency in services under the Indian Consumer Protection Act has been put to rest by the Honorable Supreme Court of India in a significant ruling. The Honorable Supreme Court in Bar of Indian Lawyers versus D.K. Gandhi, PS, National Institute of Communicable Diseases, and another has held that advocates would not be covered under the ambit of the Consumer Protection Act 1996 as re-enacted by the Consumer Protection Act 2019, collectively referred to as Acts and Consumer Law Framework. Until the said decision, there was no definite pronouncement on the concerned issue. In India, it is the Advocates Act 1961 which regulates and governs the working of the legal profession as provided under the Advocates Act. The Bar Council of India under Section 49 Clause 1 Subclause C has laid down exhaustive standards of professional conduct and etiquette. Thus, a client can always reach out to the State Bar Council where the concerned advocate is enrolled to complain about misconduct. The Bar Councils are not only vigilant, they are also sensitive to acknowledge cases involving the legal profession. It is evident that the Advocates Act already deals with issues pertaining to the conduct of lawyers. Thus, the Advocates Act, being a special law, would prevail over the framework of the Consumer Protection Act as far as conduct of the advocates is concerned. In fact, the court also pointed out that a client can sue an advocate for any criminal or civil liability arising out of professional misconduct or negligence. Furthermore, the court distinguishing between the legal and the medical profession in this particular case was apt, given that no universal standard of care or objective test exists or can be prescribed as the threshold in the case of the legal profession to adjudicate upon the question of abdication of duty to care. This lack of objective standard becomes clear when peculiar kinds of unpredictability involved in a legal case are taken into account. These strategies and outcome in a legal case are highly contingent on the steps taken by the opposite party interpretation of law, thereby making it unpredictable. 8th, expansion of legal practitioner definition. The draft bill proposes to expand the definition of legal practitioner, section 2, to include not just advocates practicing in courts, but also corporate lawyers, in-house counsel, and those engaged in legal work in private and public organizations, statutory bodies, and foreign law firms. As of now, a legal practitioner means an advocate or a vakil of any high court, a pleader, a mukhtar, or revenue agent. Several bar bodies, including the Bar Council of India, opposed certain provisions of the draft bill, citing serious implications for the legal profession and a threat to the autonomy of the Bar Council of India and State Bar Councils. Thanks for watching this video.